Nominated by President Reagan and confirmed in the Senate by a vote of 98-0, Antonin Scalia has since 1986 served as an Associate Justice of the Supreme Court of the United States. Justice Scalia's most recent book, written with Brian Garner, Reading Law: The Interpretation of Legal Texts. Quote, "We seek a return to the oldest and most commonsensical interpretive principle. In their full context, words mean what they conveyed to reasonable people at the time they were written." Close quote. Mr. Justice, in this 236th year of our republic, why should it be necessary to devote more than 400 pages to a commonsensical principle?
That's a very good question. Well, the reason, as explained in the first part of the book, is that we've sort of gone off the rails, that nowadays, especially with regard to the Constitution, the accepted view, and the view stated by my court repeatedly, is that the words don't necessarily mean what they were understood to mean at the time, but can be given new meaning. It's up to the court to say what they mean today. They mean today what they ought to mean today, and it's up to the court to decide that. The living Constitution notion, the notion that all words are ambiguous, it's really up to the court to give them meaning, is much more attractive to academics than it is to judges, and it's really the academy that brought all of this into the prominence and into the majority status that it now enjoys.
So the court lags the academy?
Yeah, I think probably. I think that probably there were law professors that were espousing these views before the courts adopted them.
All right. Reading law, once again, the purposivist, did I pronounce that one correctly?
Purposivist, yes.
Purposivist, all right. The purposivist.
Yeah, you have to have some word for them. I made it up.
The purposivist derives the meaning of text from purpose, and not purpose from the meaning of the text. That's related to the living Constitution, or that's distinct?
That's distinct. Look, there are two things that the book urges lawyers to be and judges to be. Number one is textualists. Okay, the point you just made is a point urged by someone who is not at all a textualist. He doesn't want to be bound by the text at all, and he just looks at what was the purpose of this text. And once he figures out, any purpose can be identified at an infinite number of levels, at the top of which is, do good and avoid evil. And depending on what level of generality you pick, you can make a very narrow statute into a very broad statute, because the broad purpose that it seeks is this, and therefore, even though the text does not specifically address that particular question, the question ought to be answered that way because of this text. That's a person who is not a textualist. He's a purposivist. Even if you are a textualist, though, and you say, yes, we're bound by the text, you can give the text the meaning it bore at the time, or you can say, and indeed, many of the living constitutionalists, they say, we are all textualists now. Yeah, they all start with the text,
right.
But
they don't end with it.
They don't end with it, and they don't give it the meaning it had when the people adopted it. That's especially important when you're dealing with a constitution, because a constitution takes out of the democratic process certain particular items, and you're tampering with democracy when you remove items that the people really never agreed to remove. The death penalty is a good example. I've sat with 4 colleagues who thought it was unconstitutional, even though it's absolutely clear that the American people never, ever voted to make the death penalty unconstitutional. When the Eighth Amendment was adopted, the Cruel and Unusual Punishments Clause, the death penalty was the only penalty for a felony. It was the definition of a felony. Every state had the death penalty. So nobody could plausibly claim that the American people said no state shall have the death penalty. But I've sat with 4 colleagues who have taken that position and say the death penalty is unconstitutional because it ought to be, because nowadays we ought to consider it cruel and unusual. That distorts democracy. It ought to be up to the American people to take something out of democracy, to take it away from, the Constitution doesn't require you to have the death penalty. You think it's a bad idea, persuade your fellow citizens and abolish it, as many states have done. But, to say that the American people rendered it beyond the pale of democracy is just absurd.